Welcome to the fourth webinar in our Behavior webinar series. This webinar is part of a collaboration of webinars with the South Carolina Department of Education's Office of Special Education Services, Disability Rights South Carolina, Family Connection South Carolina, ABLE South Carolina, and the Family Resource Center for Disabilities and Special Needs. The information in this webinar is meant for South Carolina residents. The title of this presentation is IDEA, which stands for Individuals with Disabilities Education Act, and Behavior. Whenever I mention IDEA in this presentation, I am referring to the Individuals with Disabilities Education Act, which is a federal law that provides special education rights. My name is Amanda Hess, and I'm an attorney with Disability Rights South Carolina. I use she, her pronouns. Visual description. There is a diverse array of decorative pictures of children with varying ages, ethnicities, and disabilities throughout the presentation. The objectives for this presentation are to be able to recognize when a change of placement occurs due to behavior, become familiar with a manifestation determination review meeting, and learn tips to prepare for a manifestation determination review meeting. We will start by discussing when there is a change of placement under IDEA due to behavior. Under IDEA, a student with a disability can be disciplined if the student violates a provision of the school's code of conduct. However, IDEA provides protections when the student is subject to a change of placement. We are going to discuss what a change of placement means on the next slide. A change of placement occurs when the student is removed for more than 10 consecutive school days. A change of placement also occurs when the student is subjected to a series of removals that constitutes a pattern. A pattern happens when the removals total more than 10 school days in a school year, the behavior is substantially similar to previous incidents, and any additional factors, such as length of removals, amount of time for the removals, proximity of the removals. A school district determines if there is a pattern. Keep in mind that in-school suspensions can be considered a removal unless the student had access to the special education services on their IEP and the opportunity to participate in the general education curriculum during the suspension, as well as have the same participation with their non-disabled peers. If a change of placement has occurred, as I just described, then a notice of change of placement decision must be provided to the parent by the school district on the date the decision to change placement is made. Procedural safeguards must also be provided to the parent. After the 10th cumulative school day of removal in a school year, the school district must provide educational services to the student. This is an important IDEA discipline protection. It enables a student with an IEP to continue to get educational services after the 10th day, even when being disciplined. These services are decided by the student's IEP team. Once a change of placement is determined, a very important meeting called a Manifestation Determination Review must be held. We are going to discuss this meeting over the next few slides. We are now going to discuss Manifestation Determination Reviews, which I will also refer to as MDR in this presentation. A Manifestation Determination Review meeting, also known as a MDR meeting, has to be held within 10 school days of a decision to change placement due to discipline. Not all required IEP team members must attend the MDR meeting. An MDR meeting consists of the parents of the student with a disability, a representative of the school district, also known as LEA, and any relevant members of the IEP team. In our experiences with MDR meetings, it is usually the IEP team. During this meeting, all relevant information in the student's file should be reviewed. This could include teacher observations or statements, incident reports, the student's IEP, behavior intervention plan if there is one, evaluation data, past year information, parent-provided information, information about the student's disability, supports and accommodations, behavioral services and strategies, any discipline records, and progress reports. At this meeting, once all the relevant information has been reviewed, the participants will answer 2 questions. The first question is whether the conduct in question was caused by or had a direct and substantial relationship to the child's disability. The second question is whether the conduct in question was the direct result of the LEA's failure to implement the IEP. If the response to either question in the previous slide is yes, then the IEP team should conduct a functional behavioral assessment, also known as FBA, and create a behavioral intervention plan, also known as BIP, if there was not one already done. If the student already had a BIP, the IEP team should review it and modify it to address the concerning behavior. The student will be returned to their previous placement unless a special circumstance applies or there is an agreement to change the student's placement. For example, if there was a proposal for expulsion, which is a change in placement requiring an MDR meeting, and the team found a manifestation at the meeting, the student would no longer be subject to the expulsion proposal. If there was a determination that the conduct was a direct result of the school district's failure to implement the student's IEP, then the school district must take steps to remedy the deficiencies. For instance, if it was found that a student didn't have access to their calm down space per the student's IEP or BIP, then the district should take steps to make sure the student has that access going forward. We suggest you ask the district what steps will be taken to remedy any deficiency if this is found at an MDR. If the response to both questions is no, then the student will be subject to the discipline. However, after 10 school days, the student will be entitled to receive educational services that the student needs to progress on meeting their IEP goals and participate in the general educational curriculum. This may take place in another setting and services may be different. The student's IEP team determines services and location and may also decide to conduct an FBA and/or develop a BIP. If there is no consensus on the manifestation determination at an MDR meeting, then the representative of the school district, also known as LEA, makes the determination. A prior written notice should be provided to the parent. We are now going to spend some time discussing tips for preparing for a manifestation determination review meeting and tips for the meeting itself. Some things to think about in preparing for a manifestation meeting. Educate yourself about manifestation meetings, like you are doing now. Find out as much as you can about the disciplinary incident before the meeting. Ask the school district for any records about the incident. This could be discipline reports, incident reports, observations, or statements, etc. Familiarize yourself with all of the student's disabilities and attributes of the disabilities. What are the symptoms and manifestations of the disability? Can those be connected to the incident that is going to be discussed at the MDR? For instance, is the student impulsive, and is that an attribute of the student's disability that can be connected to the behavioral incident? Is the child seeing any professionals that can assist with information at the meeting, such as a doctor, psychiatrist, psychologist, behavior specialist, etc.? You can bring in written information to the meeting or ask the professional if they can participate if you think that would be helpful. Review your child's school plans, such as the IEP or the behavioral intervention plan. Here are some tips to think about for the meeting itself. Bring notes to the meeting. Keep in mind that the team can consider all of the student's disabilities, even if the IEP is just based on one of them. Make sure the team has considered all relevant information, including any information you have to share. Make sure you ask any questions that you have and raise points you want to make. Maintain your composure. These generally aren't easy meetings, and don't let your emotions get the best of you. It is okay to ask for a break if you need to take a breath of air. Sometimes an IEP meeting may take place after a MDR meeting. This could be a meeting to discuss behavior and other possible interventions, a change of placement recommendation, conducting an FBA or another type of evaluation, revising the BIP, discussing accommodations and/or related services. Sometimes the move to an IEP meeting from an MDR is not clear, so just ask if that will occur if you aren't sure. A manifestation determination can be appealed by filing a request for an expedited due process hearing. Expedited means there are shorter timeframes compared to a typical due process, which means it is a faster process. There is no stay-put protection for this type of due process, which means if the student has been placed in an alternative setting and a manifestation was not found at the MDR meeting, then the student will remain there even if a due process has been filed. I mentioned earlier that if a manifestation is found, then the student is returned to their placement. That is, unless a special circumstance is raised and applied. There are three special circumstances under IDEA. They are if a student has a weapon, has illegal drugs, or inflicts serious bodily injury. If one of these circumstances applies, the student can be removed automatically to an alternative setting of up to 45 school days, even if a manifestation is found. Each of these has specific definitions that IDEA refers to. If the school district raises one of these special circumstances, ask to review the definition and how it applies. The student's IEP team determines the alternative setting and services. One other area I wanted to discuss is protections for students not found eligible for an IEP. Under the IDEA, a student with a disability that has not been found eligible for an IEP that has had a behavior resulting in school discipline can raise protections under IDEA, like a manifestation determination review meeting, if the district had knowledge that the student is a student with a disability before the behavior occurred. IDEA is very specific about what it means for a district to have knowledge. There are three ways a district can have knowledge. The first way is if the parent shared a concern in writing to supervisory or administrative personnel of the school district that their child was in need of special education and related services, like a school principal. The second way is if the parent requested an evaluation for IEP eligibility under IDEA. The third way is if the student's teacher or another staff member of the school district shared concerns about the student's behavior to the special education director or other school district supervisory personnel. We discussed the three ways a district can have knowledge in the last slide. IDEA also lists ways the district does not have knowledge. A district is not considered to have knowledge if the parent did not allow an evaluation under IDEA, the parent refused special education and related services, or if the child was evaluated and not determined eligible for special education and related services. If the district is not considered to have knowledge, then the student can be disciplined like any other student, and IDEA protections will not apply. A parent can request an evaluation for eligibility for an IEP under IDEA during the discipline. In this instance, the evaluation will be expedited. However, the student must remain in the disciplinary placement. This slide provides some resources that can be found on the internet. This slide provides website information for Disability Rights South Carolina's education resources, which is https://www.dislsc.org/resources/education/. Family Connection of South Carolina is our state's current parent training information center. Its website is https://www.famlitylight.org/resources/education/. ilynectionist.org/education/. South Carolina Department of Education's Office of Special Education's Parent Resources website can be found at https://ed.sc.gov/special-special-resources/. This slide provides some more resources that can be found on the internet. This slide provides website information for the Family Resource Center for Disabilities and Special Needs Resources page, which can be found at https://frcsc.org/resources/. The Family Resource Center is a parent training and resource center covering Charleston, Dorchester, and Berkeley counties in South Carolina. U.S. Department of Education has discipline and behavior resources, which can be found at https://idea.gov/topic-behavioral-supports. The Wright's Law website has a Behavior Problems and Discipline section at https://www.wrcl.discipl.index.htm. I thank you for your time, and I hope you found this webinar helpful. This slide applies to Disability Rights South Carolina, which is also referred to as DRSC in this presentation. This presentation provides general information not intended to be legal advice. The information was based on the law at the time it was written. As the law may change, please contact DRSC for updates. This presentation is funded by the U.S. Department of Health and Human Services, the Administration for Community Living and the Substance Abuse and Mental Health Services Administration, and by the U.S. Department of Education, Rehabilitation Services Administration. It does not necessarily represent the official views of the funding authorities. The views expressed are solely those of DRSC.